Today we're talking mediation. I'm John Henderson with HH Law, here to help define what is mediation. Mediation is a term that gets tossed around as some sort of negotiated agreement or some sort of negotiated situation a lot. Well, in family court, just like in civil court, mediation is a tool that family law attorneys use to try to get exactly what you think it is, a negotiated agreement between two parties, between you and your spouse or two spouses together. So in South Carolina, in fact, most counties, you have to have mediation. But mediation is really an opportunity more so than a check mark or a requirement or a hoop that you have to jump through. Mediation works beautifully when the mediator is good and then the parties have decent legal representation and come into it with the mindset of trying to get a resolution rather than making a judge make a decision. What usually happens, just to give you a little bit of context about why mediation comes about, is because judges, yes, they are elevated referees. I mean, they're much more, I don't mean that in a disrespectful sense. I mean that in a sense to family court judges and judges everywhere, that they're trying to stay out of the issues involved to a great extent. They will certainly have to make very important decisions, but they are going to be sitting back, hopefully getting the lawyers and the two sides to duke it out a little bit, to argue, use their rhetorical skills or whatever to try to make their points and negotiate between the two of them to resolve issues. Judges generally want parties in legal representation to try to hash out all those issues. They're sitting there making sure that everybody's playing by the rules, and then they will make decisions when they have to make decisions. So with that broad context, mediation has emerged over the last couple decades to the point that now it is mandatory in most counties in the state of South Carolina, mandatory in many, many counties throughout the entire country. And really what happens is you show up to mediation well-armed and well-versed on your case. So when we represent somebody, we create a mediation binder. It has all the facts of the case, all the evidence that we have, all of the information necessary to be able to argue our points during that day. The lawyer on the other side does the exact same thing. We show up to the mediator's office. The mediator is the neutral third-party attorney, usually, who has more gray hairs than I have most often, although I mediate cases as well, but somebody who has enough experience that they've seen it all kind of thing. You want somebody like that to be your mediator, not somebody who's green and new to the practice of law. You want somebody who has won a bunch of cases, lost a bunch of cases, won cases they thought that they were going to lose, lost cases they thought they were going to win, who understands and is litigating and involved in the litigation process enough that they understand what particular judges might be doing, what the nuanced issues of the day are. So you need somebody with a vast amount of experience to help nudge the parties. A lot of times you'll start together in the same room. There's an introduction. Both sides pitch a little bit of their case. In family law, different than civil law, you may skip that and go straight to what they call a caucus. You caucus in one room, your spouse is in the other. This is how this goes. They're in different rooms, so there's not too much fighting. The glares are reduced. Emotions are able to be worked out a little bit easier that way. The mediator goes to the first room, hears their side of the story, goes to the second room, hears their side of the story, and then it tries to identify what are the big issues that we're going to work out today. And then the mediator goes back and forth trying to negotiate settlement terms all day long to try to make sure that the parties are good with them. And if all goes well, the mediator is able to share experiences, tell both sides privately, and that's an important part of this, that it's private. The mediator is not going and telling the other side private information and vice versa. So the mediator a lot of times what they tell you in mediation training is that really you're the holder of the deal, okay? And you cannot get a deal together. You're not going to be able to get a negotiated agreement between the two sides if you're violating trust. So really the mediator is having a private meeting here and a private meeting here and taking offers back and forth to each other, trying to move the needle a little bit to try to inch people together and check some of the issues off. Okay, we've addressed custody. We've addressed who's getting the house. We've addressed who's doing the cars, who's doing insurance, all these different things. But now we have a rental property that is heavily litigated. But at least the mediator is able to get an agreement on as many issues as possible by the end of the day. If all goes well, there is a signed agreement. People will take a paper just like this. The mediator will write it all up, and they will have a signed agreement. Type it out. Both attorneys will review it. Both sides will review it. Sign their name to it. That is a binding agreement that the mediator can then have as evidence, sends a copy to both parties. The lawyers from there try to get the language figured out. One of the parties' lawyers will be assigned the duty of making a draft of this, sending it to the other lawyer. A lot of times there's a little bit more back and forth between the lawyers about exactly what the terms were. So it's important that you have a mediator who is getting down every single detail. More is better than less in this instance, because you don't want a miscommunication about holidays. For instance, this happens a lot, is we're going to alternate Christmas 1 and Christmas 2. That is like who gets the first half of Christmas break and who gets the second half. You'll get that negotiated agreement, something worked out, but then forget to say who gets this Christmas, who starts with Christmas 1 or Christmas 2 or something like that. And now you kind of got the lawyers going back and forth. So more details are better than less. But mediation is a wonderful tool in general. And the other thing about mediation is that if it doesn't work, it's all confidential. It's all private. Nothing that goes on, no offers that are made can ever be communicated again outside of that mediation day. You can't bring it back up. This is all to encourage an honest, helpful negotiation of terms. But once you leave mediation, you don't have an agreement, none of the information that was discussed or disclosed is allowed to be brought back up again at a later time. So mediation is a wonderful way of making people come to an agreement. A lot of times, and you'll hear this from your mediator probably, is that a successful mediation means that party A is a little bit disappointed and party B is a little bit disappointed, but neither party is mad or feels bamboozled or anything like that. Everybody's just a little bit disappointed, got a little bit less than they were hoping for on mediation day. That's a pretty successful mediation, because at least you are the master of your own destiny when you're sitting there at the mediation table. And for my part, I can't imagine a time that we have ever left the mediation table. I'm going to sit there with my client as long as that my client wants me to sit there and engage. But a lot of times that means that we have to sit there and stay until 5 o'clock, 6 o'clock, 7 p.m. in order to try to get things worked out. And we're devoted to trying to do that. We're not walking away from the mediating table, the negotiating table, until we know exactly what the other side is willing to do. And often it takes very late into the afternoon to make the deal, to try to figure out what they're willing to do and what we, in fact, are willing to do. Anyway, that is just a brief synopsis of what mediation is, why I think that it's important, why it has been such a strong push and wave throughout many court systems in the United States. We are located in the state of South Carolina, wonderful state of South Carolina. We encourage you, if you have a question about any sort of legal issue, we are a full service law firm, but our family law division is particularly devoted to helping people with custody and divorce issues. If you or a loved one needs any help, please contact our office. And if you live outside of the state of South Carolina, we encourage you to use these videos as tools to help arm you with information and knowledge to help you make decisions in the best interest of you and your family. But you do need to consult a lawyer on a local level to try to get case-specific, state-specific advice. I'm John Henderson with HH Law. Thanks for watching.